Hi, my name is Arati and I'm a journalist at MediaNama. I'm delighted to welcome you all to the research presentations for the 2022 cohort of the Meta India Tech Scholars. Meta launched the program to provide a research and mentorship platform to law students who are keen to engage on contemporary questions of technology, law, and policy. The law firm Shardul Amarchand Mangaldas Co is supporting the program as a knowledge partner. Through this series, the scholars will show us how specific policy choices in the technology sector influence and impact India's tryst with the internet. For today's showcase, I'm delighted to introduce you to Kaustubh. Kaustubh graduated from the National Law School of India University, Bangalore in 2023. He is now practicing as an advocate across various fora in Delhi, including the High Court and the Supreme Court. His research over the past year was focused on the grant of safe harbor to AI chatbots, and this interest in technology law has carried over to his practice, where he is dealing with contentious issues like a challenge to the VPN guidelines that prescribe the storing of consumer data by VPN providers. I look forward to hearing from you, Kaustubh, and you're free to take it ahead.
Thank you, Aarti. Lovely to speak to you as always. So I'm going to, at this point, put on a small PPT. I'm not a big PowerPoint person. Generally, this will only really be for your very broad reference. Just one moment. Could you just confirm for me once this is visible, and so then I can carry on from there?
Yes, perfectly fine.
Okay, that's great. So I'm just going to start now. One moment. So, like Aarti flagged for all of you, I'm working broadly on the idea of a safe harbor being granted to AI chatbots. Briefly, what does this mean? It means I'm dealing with the suggestion that we should, in some or the other way and to some or the other degree, exempt these AI chatbots from legal liability they would otherwise incur. Uh, Very briefly, then, I'd like to flag that I'm dealing with only AI chatbots. So I'm dealing with ChatGPT. I'm not dealing with a rule-based chatbot. So most of the internet, for example, right now consists of rule-based chatbots, which are pre-coded to give certain information or certain responses when posed with specific questions framed in a specific way. They don't learn, they don't have natural language processing. They're rule-based, the same way an IVR system on a phone helpline might be. So that's not my purview. I'm dealing with AI chatbots. The reason I'm dealing with this issue and the reason this has come to the fore for me personally is I love thinking about large problems. And to my mind, this is the largest problem that's facing the tech regulation landscape right now. Not because of AI chatbots as they are, but because of what they could be. So my interest in this comes from my interest in artificial general intelligence more generally. So I've thought about and written about artificial general intelligence and how we might achieve that. AI chatbots are as of now at least, fairly viable, likely pathway to achieving artificial general intelligence. And the achievement of AGI would likely be revolutionary, that it would change the way our global societal order works completely. It would be more revolutionary than the internet. And so my interest in AI chatbots and protecting them from liability comes from that potential. And it comes from the idea that if we don't step in right now and make sure that this development goes as it can go, we might be losing out on a lot of value in the future. And so that's broadly what draws me to this problem. I'm going to go through this in a two-step way. I'm going to first explain to you what my understanding of the underlying basis for the grant of a safe harbor might ever be. Theoretically, why do I as a government ever choose to grant safe harbor? Because obviously that cannot be my default. And then I'm going to take that underlying logic, that underlying rationale, and I'm going to apply it to AI chatbots. And I'm going to show you why this is a fit case. After which, of course, I deal with a few possible objections, of which there are many viable, serious objections. And then we'll briefly conclude, and hopefully I'll have a couple of minutes to talk to Aarti left after that if I haven't overshot my time very, very horribly. So now on the first question then, which is the question of the theoretical basis for the grant of a safe harbor. Briefly, I have here flagged three things that I think are good theoretical bases for granting safe harbor. They sound logically and they've also been borne out historically. So the first and the most common historically has been when we're promoting a specific type of innovation. Very simply put, there's a young fledgling technology. The government wants that young fledgling technology to become mainstream. They want it to grow. They're concerned if they don't grant some sort of shield against liability, it may not grow. So this happened, for instance, when governments granted air carriers a degree of exemption from liability for plane crashes. It happened when civilian nuclear energy providers were granted a degree of exemption from liability for nuclear accidents. It's when there's technology that we want adopted, the government may then make that choice. They may say, in public interest, we're going to promote your business, we're going to grant a safe harbor. So that's theoretical basis number one. Theoretical basis number two is when, again, in the public interest, I say I will subsidize a pre-existing business which is already entrenched and which doesn't need my protection. But I believe that the grant of a safe harbor here will in some way be to the public good. The best example of this, as far as from the top of my head, is in the US, where liability shields were granted to doctors for medical malpractice cases. So basically, I do something horribly wrong and the patient suffers, the patient perhaps dies. I cannot be held liable. And the rationale there was that, well, if we don't do this, insurance costs will spike, continue to spike, go through the roof, and make medical services inaccessible. And so it's a necessity to our mind in the public good that this be done. So both of these prongs are reasonable prongs, they're reasonable grounds. They are, however, in my opinion at least, not judicially enforceable grounds. So if I want to grant a safe harbor as the government, that's something I can do for reason one, for reason two. If I, as the judiciary, want to grant a safe harbor, I can only do it on prong three. Because I can't just say, here's my policy decision in the public interest. What I can say is, if you are to not grant a safe harbor, if that were to be blatantly unfair, if that safe harbor is necessary, then there might be some scope for intervention there. So prong number three, therefore, is a little bit broader. It's implementable by a larger number of actors. It's the idea that a safe harbor may be necessary for a business to exist, and we want that business to exist, that the non-granting of that safe harbor is unfair. And this is when we go back to the internet. This is when we go back to the most widely understood, the most common safe harbor there is, internet intermediaries. When we all come together and say, hey, listen, if we don't grant Google safe harbor, Google cannot work. And so we must grant it safe harbor. And then we define intermediaries and we say, okay, all intermediaries like Google, which aren't really doing too much, but making content available to us without interfering with that content really, must be granted safe harbor, because if they are to be made liable for every single piece of content we access through them, they will cease to work. And so these are the three broad theoretical bases I've identified. Now, the third basis especially is what I want to touch upon on while examining artificial intelligence-based chatbots and looking at whether that basis can be applied, culled out and applied to AI chatbots. Now, then that means we need to look at three things. We need to understand how these AI chatbots, first of all, are trained. We need to understand how this learning process works for them. And then we need to understand why the liability that may accrue is not dissimilar to the liability that, for example, Google might be dealing with. Now, here's what's relevant while understanding how they're trained in. I don't want to go into technical details unnecessarily, but here is what is critical to know. First off, they're trained using scraping processes. What does that mean? It means a large, massive amount of data is taken through from across the internet, 45,000 GB, for example, of text, just text for ChatGPT-3, and 100 times that for ChatGPT-4. It's scraped from across the internet, from every source the developer can lay their hands on. And then the AI is trained on all of that text using the natural language processing model that they have and building a large language model that allows that chatbot to actually engage with the user to answer queries to function. Now, what's necessary here to understand is this. While building a large language model, which is the bulwark of the functioning of any AI chatbot, the amount of data I can feed in, the amount of data I've been able to scrape, directly correlates to the quality of the AI chatbot. So while judging whether an AI chatbot is good, I look at the number of different queries it can engage with. I look at how it can adapt. I look at how accurate is it. All of those things require it to develop parameters, which is ways in which it can respond and engage that are different. The more data I feed that chatbot, the more the parameters. And so functionally today, to develop an AI chatbot is to enter into a weapons war on how much data can I possibly procure to feed my chatbot. And we're dealing with voluminous amounts of data now, like truly absurd. And that's how these chatbots are trained. And without that kind of data, they cannot be trained. What does that mean in terms of learning? It means that unsupervised learning has become necessary. Functionally, if I were dealing with a small amount of data, let's say I had 1 GB of text I needed to feed. I, as the developer, could hire people or could perhaps even personally go through every inch of that data every inch of that text and say, is this good text? Is this accurate text? Is this not violating any laws? Is this defamatory? Is this violative of IPR? And I could only then feed it in. The moment I'm dealing with a volume of text, with a volume of data that is not practically viably readable by any team of individuals, no matter how large, at that moment, I am going to be training my chatbot using unsupervised learning. I will be feeding and cramming all this data in and hoping the chatbot makes sense of it. That my natural language processing, that my large language models are good enough that they can take this data and do something with it. And so inherently, I'm now at a point where it's impossible for me, if I want to develop an AI chatbot of any quality, to actually go through all the data I'm going to feed in. Now, what does this mean in liability terms? It means that just as with Google 20 years ago, just as with search engines, it's functionally impossible for me to actually regulate and have any kind of check over all of the data that I am going to be throwing out, all of the answers I will be throwing out, and all of the data that's the foundation for those answers. And so consequently, while unlike with Google and unlike with intermediaries as traditionally understood, I am not simply storing and relaying content. I am in fact using that content to do something new, to answer, to have my own content functionally. The underlying basis for that liability shield that was granted all those years ago, the basis being that this is a business which we read and is a business which cannot function, absolutely impossible for it to function if I don't grant it that kind of exemption, is also applicable here. Because we're dealing with the same massive volume of text, of data, and the complete impossibility of ensuring that I'm not going to violate the law while developing an AI chatbot. And so, to my mind, the same underlying logic should be applicable here as well. This does not, of course, mean that there can be no objections in the present case. In fact, there are many. I'm going to go through three here. There are many more. These, to my mind, are the three most viable. And each of them must be considered long and hard. And I'm not making a case that these can be overlooked. I'm simply saying that these need to be internalized. So the first, of course, is the idea that if you are going to infringe, and that's baked into the pie in a manner of speaking, why don't you internalize the cost of that infringement? So rather than the government stepping in and saying, hey, we grant you a liability shield, why don't you instead personally pay out as and when someone files a lawsuit against you because you likely are infringing? And then you internalize the cost of that infringement and you pass it on to your consumers. You price your product such that the consumer then pays for it de facto, which is how this would ordinarily work in a free market. Now, the problem with that is this. If I have a situation where I, as the consumer, am having to pay a markedly higher cost for a product because of the infringement of others, and I, as an individual infringer, face no real consequences for my infringement, because the moment the cost of that infringement is at the initial level being borne by the search engine, by the intermediary, by the AI chatbot, there is no incentive to go after the original infringer. Nobody is going to do that. They'll sue Google. Google will then pass the cost on to all of its consumers, right? At that point, it's a very real moral hazard, because I, as the consumer, then am in a position where I'm either left holding the bag for and paying for everybody else's infringement instead of my own, or I also infringe. Why should I pay extra to watch a movie when I'm anyway paying for the hundreds and thousands of others who are watching movies while infringing? And so that's not an ecosystem we want developed. So that's problem one. Problem two is the value gap. And this is much harder to solve. This is the idea that in a free market, where I could be held liable for using your content without your express authorization, I have much more incentive to enter into an equitable deal with you for using your content. I have much more incentive to pay you the right fee, to pay you the right royalty. The moment I can't be held liable, that incentive goes away. And so now, consequently, I have immense leverage when negotiating with you how much I can and should pay you. And so, consequently, that value gap begins to arise where that guy, his data is giving a lot of value to me, but I'm not giving that much value to him, and I'm not paying him for the value he's giving me. Now, there is no easy and obvious solution to this. This is a problem that antitrust regulators, that IPR regulators have been dealing with, frankly, in different forms for decades. My submission simply is deal with it here also. This is not inherent to the creation of a safe harbor. Just because it can be exploited in this way does not mean it necessarily will be. Try to regulate it out. And when you can't, penalize the chatbot developer in question for taking such sharp tactics. That's when competition law comes in, for example. But this objection isn't a reason to discontinue the existence of a safe harbor necessary for the product to succeed and exist, is all I'm saying. The third possible objection is that The principle I espouse is that I don't want them to have to pay lots of money and become unviable because the underlying data has a flaw. However, in some cases, the errors might simply be resulting from a flaw in the model of the developer himself. The flaw might not be with the data. The legal liability issue might not arise from the data. It might arise from the way I am translating that data into answers. And so at that point, there is no real reason or principle to exempt me from liability. That's fair. My response to this is very simple. It's possible that errors might simply be resulting from flaws in the LLM and not from the underlying data. It is, however, also practically impossible to discern what that error is arising from on a preliminary level. If my point here is that I want to make this business viable and not litigated out of existence right now, because it contains within it the seeds of life changing, world altering technology, I must take on the higher burden of accounting for all these errors. Because the moment I don't, the moment I say, hey, I give you an exemption from liability for prong A, but not for prong B, every individual litigant will then always, and there's a lot of interesting empirical work that's been done in the US to reflect this on statutes, for example, insurance statutes that cover some situations but not others. Everybody will obviously frame their claim as a claim arising from the non protected category. And consequently, their insurance costs will go up today. Their technology will therefore become unviable financially today. And so, consequently, if I am to stick to my original objective, I must take on the higher cost of covering for errors also arising from flaws in the LLM. Uh, that's broadly the crux of my reasoning. But in conclusion, briefly, I will say that this is a problem that is arising today. That last week, New York Times filed a lawsuit. That last month, a class action lawsuit was filed. That these are issues to be litigated right now. And so, if we don't move on this fast, and if this technology suffers too much in its development nascent period right now, then that's a very real problem. Uh, I don't use any of this to say that the conversation should only be about complete exemptions from liability. Rather, I write this and I work on this to shift a conversation that right now has become about denying liability to intermediaries. Every subsequent bill that's getting proposed, every subsequent law that we're talking about, limits intermediary liability in exemptions. It limits the safe harbor that's being granted, says only in some cases, only to some intermediaries. I think we need to push the ball back a little bit in the other direction for this one product and this one product only. And that's the objective of my research. This isn't my saying this is the exact kind of safe harbor to be granted. This isn't my saying have a notice and take down regime. This isn't my saying grant a blanket safe harbor. This isn't even my saying, oh, you can only grant it to some AI chatbots or to others. I don't know yet. And those are conversations that I have preliminary thoughts on, but I haven't fully fleshed those ideas out yet. This instead is meant to be a launch point for a conversation in the opposite direction. Because right now, no one's talking about this. No one's saying, oh, maybe we should extend safe harbor for intermediaries. And I submit that we should. And we should submit it in this one case, we should extend it. And then once we can arrive at a degree of consensus on the necessity for the safe harbor, we can then perhaps move to another conversation about the nature of that safe harbor. That's all from me on this very, very brief overall kind of presentation. And if anyone, of course, has more questions, then I'm happy for them to email me. Hi, Aarti.
Right. Thanks so much for that, Costa. That's really interesting kind of exposition on the regulatory gap that surrounds AI, especially in India and perhaps elsewhere in the world as well. I think my first question that I had when listening to you, and as someone who reports and writes a lot about safe harbor, whether in India or otherwise, is really where does the buck stop? Because it's very easy in the case of, say, AI, which is sort of positioned and marketed as groundbreaking, path-breaking, once in a generation kind of technology to say, carve out the exception. It may not be an intermediary in the case that you're talking about, but it's okay because, there are, real businesses and public interests surrounding the technology. But my question is what that essentially means is that you're reframing the concept of safe harbor as something that can technically apply to non-intermediary technologies. So in that context, how do we think about risk? How do we think about safety? How do we think about safeguards? Because intermediaries, it's sort of easy to give them a free pass because they're also seen as somewhat benign in some sense, right? They're not doing anything. So in these cases, how do you build in those legal protections for risk when you're dealing with non-intermediary technologies, Is doing that even possible? And if it's not, what are the sort of consequences that we can portend for generations to come of these technologies as well? So just curious to hear your thoughts.
There are three thoughts on that. First, you're right, it will make the regulatory landscape much more complex.
Right,
That's inherent. The moment I go from a cookie cutter definition to a more nuanced case by case analysis, that's a problem that comes with the territory. And I'm fine with that. Because
right,
to my dealing with complex technology inherently means I sometimes have to deal with complex regulation. And so that's a cost to be paid. And that's a cost I live with. But secondly, I will say that this doesn't apply nearly as broadly as you might imagine at a first glance. Of course, it will now apply to certain non-intermediaries. That's fine. It will not, however, apply to, for example, all emerging technologies, or even all AI-related emerging technologies that aren't intermediaries, because the criteria that needs to be fulfilled is still one of, is this a product one that we need promoted? Is it one that cannot be promoted without the grant of a safe harbor? Is it necessary? Would it be unfair to deny that safe harbor? Now, with AI chatbots, you have a situation where the development of the technology is inherently tied to the infringement. I cannot functionally develop any large scale LLM, any AI chatbot without scraping that data. And so if I don't grant you that safe harbor, the very root of your business goes. That's a very high threshold. When I'm
mm,
dealing, for example, with self-driving cars, as we're seeing in California recently, without any kind of safe harbor or anything being granted, you can still develop those cars in a way that's safe. I
right,
don't need to grant you a safe harbor against all accidents simply because you could have accidents, because frankly, it's not necessary. I can develop this technology on a piecemeal basis and increasingly and granularly increase the exposure to risk, increase the degree of autonomy that the car has, little by little by little, while training it in a way that is still safe, that isn't dealing with real people on the road. All of which is to say, it's only when it's inherent to the technology that it's A, this important, and B, will necessarily infringe, that I'm talking about safe harbors like this. And so, to my mind, almost no other real, frankly, adaptation of this technology requires such a safe harbor. So I am pushing the guardrails a little bit out there, but I'm not pushing them that much. I'm
mm,
pushing them for one very narrow use case.
right.
Uh, Thirdly, even in this case, guardrails can be built in.
Okay.
What does it look like? I can't say till I see a legislation doing it, but for example, I could allow for this exemption to be granted to some AI chatbots and not others, for example. So that's the most easy, low grade guardrail I can think of. I can go out and say OpenAI has the funding that can afford this. Its smaller competitor does not. I don't want this to become a one party driven market. And
Mm,
so I give this to the smaller competitor and not the large guy. I can give it on certain types of infringement. I can say, okay, for IPR, I grant this to you, but for defamation, I don't.
right.
Because, or the other way around, frankly, which to my mind is more intuitive because defamation is harder to tell as a developer. So there's any number of things I can do. None of this is to say a blanket provision needs to be put into place saying no liability ever for anything. This is simply to say that there needs to be a degree of exemption. And let's talk about that kind of exemption. And there are many. There are
Right.
many levels. There are different kinds of regimes that can evolve. The world already has 17 types of different regimes on intermediary liability, right? You can modulate that. And I think there's a number of options that can work for us. But we need to start talking about having something. And that's really all I'm getting at here.
Right. And just out of curiosity, are there any governments that have conceded to your idea or like have, followed in your footsteps and are thinking of waiving safe harbor in the case of these specific use cases, or is that still a nascent idea?
It's a nascent idea. It's been pushed a little bit by some AI developers.
Hmm.
And governments, as far as I understand it, have basically responded with ha 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 no. It's roughly where we're at. Nobody's
That's what
taking
I was thinking. Yeah.
no one's taking it very seriously.
Yeah.
And I think it's a little bit tragic because I honestly in a political process, it's hard to account for big ideas. It's hard to account for controversial ideas. That then must come from academia. That must then come from policy because no government will take seriously ideas like, hey, exempt us of all of our liability. Somebody needs to make that argument without necessarily coming from the chatbot. And the guy
Right.
is coming from it. And so I see that as important right now.
Right. And just on a final closing note, so I think your whole premise kind of really well articulates the benefits of granting safe harbor to
Mm.
these limited use cases. And I understand them. And I think especially the economic points are super well taken. But the reality, as you just mentioned, that we're facing right now is that that may not actually happen. And if it does, it might happen, say, after a couple of years, if at all. So, what do you see the future of the industry as in a world where they don't have these exemptions from liability in specific cases? and where, especially whether it's in the EU or elsewhere, you're looking at fairly stringent kind of regulation towards these kind of technologies as well. So how do you see the industry evolving given the current reality and scenario?
Two primary things. First of all, I think what you'll then have is a centering of development around a very narrow range of developers. Now, this is an inherent risk with any large scale technology. You always will have larger companies pushing it down.
Right.
But with AI, we avoided that to a degree. OpenAI for the longest time wasn't the big player. And they still right now are at the forefront. So you had smaller players with highly technical individuals being able to push the envelope. The more I go down the road of legal liability being imposed, the more only Google can do it, the more only Microsoft can do it. Because they might have the deep pockets that allow them to justify paying out voluminous amounts of money in lawsuits. Almost nobody else does. And so consequently, you have almost definitely an orientation of the market heavily towards large players, which anyways inherent risk with AI. And so you exacerbate that significantly. And you practically make it impossible for lower cost, non-profit driven entities
Mm.
to have any real role. That's
Right.
part one. Spillover effect of that, part two, is anyone's game. What happens when you only have the biggest for-profit players developing technology? It will develop a certain way. It will develop in a way that's profit maximizing. It may not develop in a way that's perhaps best for society. That's wildly speculative. Effect one, I'm sure of. Effect two is speculative, and well, frankly, it will likely occur, but how exactly it occurs remains to be seen. How they monetize it, how they restrict access, how it's used moving forward, I think is a question to be asked as and when it does occur. But it is going to happen, undoubtedly. When you give only two really powerful corporations the ability to run the market entirely on their own.
Mm. Fair enough. Well, thank you so much for this, Kaustubh. This has been a great experience. If you'd like to read more about Kaustubh's work or any of the other meta scholars, feel free to head to our YouTube channel or the MediaNama website, where you can see a full gallery of all these presentations from this year and last year. Thanks a lot, Kaustubh, for joining us today.
Thank you, Aarti. My pleasure.